Yes.
Adjournment request from item number 1 to 7. From item number 8 to 14. From item number 15 to 28.
Maybe your lordship, item number 21 or adjournment. Adjournment slips are deeply obliged.
Take the date. Take the date.
22nd April.
Also, in item 16, we are seeking an adjournment.
Same. All right.
Can be on Monday, your lordship.
Item number 16.
16.
You have circulated the adjournment slip.
Yes, your lordship.
So whether he's on legs or not, he grant time.
1st April. Item 29 to 32. Adjournment request.
Sure. So I beg to mention item number 22 to kindly pass over for the day lordship.
Item number?
22. Yes, we have to file an additional affidavit lordship.
You're for appellant.
Yes, lordship.
Have you informed the other side?
No, it was-
Without information, we will not. There must be somebody must be here watching. Let the case be called out. You mentioned then, if the other side lawyer is here, he will take consent from it. I mean, we don't have to take consent, but we will let him know that the matter is being adjourned.
Okay.
We don't know what is the urgency in the matter. So when the case is called out.
From item number 29 to 32. Adjournment request. Item 33 to 39.
Please, your lordship. This is with regard to item number 37. We have circulated the adjournment slip and taken counsel. Much obliged. 37.
27 April. Any other request?
May I please, your lordship? Your lordship, I have filed one writ petition yesterday only.
You always have to tell them that you do louder, please. Yes.
May I please, your lordship? Your lordship, I have filed one writ.
Use your lung power. You must be audible. Don't depend upon that amplifier. Speak loudly.
Yes, sir. Your lordship, I have filed one writ petition yesterday only, your lordship, against the Assam Tea Provident Fund organizations. Thereby, there is a conflict in between the SURFACE action as well as the Assam Tea Provident Act. And they have issued one notice on 7th. And by 12th, they have fixed the date of appointment of receiver. And we have already attached the, your lordship may kindly.
You file it tomorrow. If it is defect free, it shall be listed. You filed it yesterday.
Yes, your lordship.
It will be listed if defect free tomorrow.
Your lordship, can it be today? Because tomorrow is.
If you show the urgency, argue it tomorrow. Tomorrow.
May I appeal, lordship? I'd like to mention for listing one review petition mail filed on 18 to 2026.
Review of whose judgment?
Yes, Miller. In the yes, Miller.
This court.
Yes, this court.
Discomposition.
This constitution.
Yes, Miller.
All right. And what is the review about?
Miller, section 18 and section 18 of the Panchayat Act, Miller. And there is a Miller a quorum and Miller 46(3) of the Constitution, Miller rules, Miller. That part may be clarified by this report. 46(3).
When do you want it?
Monday, Miller.
Monday night.
Okay.
Daily list for orders item 1.
Yes, what do you want? Mr. Raghav Kapoor, what do you want? Mr. Raghav Kapoor, what do you want?
Your Honor,
You have to, yes.
Your Honor, there is a request. Your Honor, on Monday, there was a matter which was listed at item number 9. So,
Yes.
Your Honor, the date which was taken in that matter was 27th of April. Now,
Yes.
my lords, once I went back home, it was apprised by my father that there is a marriage which my Tayaji has informed me.
Want?
I want, Your Honor, I want that date to be preponed to
Preponement is not
20th
possible.
of March, as I had a word with the opposition. They are okay with that, my lords.
They
So
may
I
be
want the
okay, but
request is that the
preponement is-
matter to be taken up for 20th of March.
It has to go in April. We can accommodate by extending the date.
Matter, Lordships, I appear on the other side, my lord. If it may please be taken up anytime in the month of May, my lord, there's no urgency in the matter. If he goes to jail, he goes to jail.
No, that you can say the person who is approaching this.
If this honorable court arrives at a finding that he is guilty to be, he's liable to be punished for contempt, he goes to jail, my lords. There's no urgency in the matter.
All right, on that day, if you're not there, we will adjourn the matter again.
Deeply.
But no preponements. Chalo, next.
Item number 1.
The review petition yesterday, my lord, was pleased to issue condone the delay, my lord, and pleased to fix the matter on 8th of April. So may I pray the matter will be taken up on after 8?
What is the number of review?
Yesterday delay was condoned, my lord. Has not yet been numbered, my lord.
The other group. So the number has not been given. But we say so. They can
Give the serial number along with which.
let this contempt case be listed along with the review number so and so on so and so.
Serial number is 7174. Oblige, lordship.
717. Item number 2.
Yes.
My lord, in this case, my lord,
Contempt also will go to that.
all the respondents have, my lord, filed their affidavit and I have filed my reply, my lord. This is regarding unauthorized construction.
Ready? Yes, argue. You want it to be listed under admission.
Yes, my lord.
It's a contempt matter.
My lord, in
You
fact,
can come only notice. Yes, argue.
my lord, they have stopped the construction, but the unauthorized portion has not yet been demolished. That
There is
is,
no contempt that way. It's a separate.
yes, my lord.
Are they continuing with the construction?
No, my lord, they have
Then
stopped, my lord.
I don't think you should press this.
After filing this contempt petition, they have
After
stopped.
filing this contempt petition, so we rest it at this. The Land Council for the petitioner fairly states that the ongoing construction has been stopped, but only after the filing of the present contempt petition. We would like to. We would like to caution that this court would not brook of any violation of it, any breach of its order. Henceforth, we thus deem it appropriate to rest this contempt petition with the direction that without appropriate approval, the construction work ought not to be started.
Right.
Petitioner stands disposed of.
Item number 3.
May I please question, my lord, I have taken steps by way of speed boss. However, the report has been addressly left.
Awaiting the service of notice on respondent number 7. You have not taken steps for issuing the notice by usual mode. Take some time, file that requisite. No step appears to have been taken for issuing the notice on respondent number 7 by usual process. Let requisites for issuance of notice under usual process be filed by the applicant within a period of 2 weeks, returnable on your date after 6 weeks.
6 May. Item 4.
Yes, what is? May I please, sir?
Your Lordship, service is completed.
There
Yes,
is a delay of 230 days, Your Lordship.
we'll come down there.
Yes, sir.
Because that, look at him. Delay condoned, appeal to be processed.
Item 5,
Jitne orders hai, unko-
May it please, Your Lordship.
Yes, what is this?
Your Lordship, this is for the restoration of the writ petition, which was dismissed for non-prosecution on 19th of February. It was
For the reasons stated, the case is restored.
deeply,
Sufficient reason for detail.
deeply.
We restore such cases.
Lordship. Yeah, this is relating to surface measures. Item number 6,
Yes, yes,
On appearance,
no years, my lord, restored.
restored to its original intent. Detail.
4, 5. Item 7,
May it please your lordship, my lord, the order against which this contempt application file is met page 8, my lord. And relevant for page 8 is the order, my lord, order dated, my lord, 6/8/2025. And the relevant portion, lordship, page 12, there are 13, my lord. Discharge order was interfered with and they directed, my
You have
lord.
not been permitted.
No, my lord, yes, my lord, not been till that, my lord. I made myself available there, my lord.
The petitioner contends that despite a categorical order, despite a categorical direction by this court, by judgment dated 6/8/2025, to allow the petitioner to resume his training at the earliest, subject to his being found. Subject to his being found otherwise fit for joining the training. He is not being permitted to join. Let notice be issued to respond number 2. No, respond number 3. Respond number, not chief of arts.
One and two.
To respond number 3, on the steps being taken by the petitioner within a period of 1 week, both modes returnable after 4 weeks. Okay. Respond number 2, incorrect.
29-4.
Obliged.
Item number 8,
Is a
Yes.
lordship, they state the appeal, lordship, there is a delay of 120 days, lordship.
Notice to go first time.
Notice may be issued.
Notice.
Deeply.
Returnable so and so 4 weeks, 1 week requisites, no, and then 4 weeks.
Lordship.
Returnable.
Lordship.
6 May. Item 9,
20 days.
Please, your lordship.
You don't need to issue notice here. Who is the private respondent?
Yes, lordship.
Then let notice be issued. Both modes returnable, so and so that.
Yes, lordship.
item 10,
May I please? There is
For the first time, 42 days,
delay of 240.
204 days.
Item 11,
Lordship, delay of 42 days. There is a caveat. I have already served
Doesn't matter, notice.
similar matter are fixed on 8/4.
It's for. Yes, follow.
Item 12.
You're appearing for the response. You want to respond?
Yes, my lord.
All right. Okay, this is an application on behalf of the state of Assam for condoning the delay of 844 days in preferring the speed. So Mr. So-and-so learned advocate who is appeared for the respondent. Number?
Sole respondent.
No,
we will be appearing for OP number 1, opposite particular.
Respondent submits that he shall contest this application by filing by filing a record affidavit. Let such a response affidavit be filed. Let such affidavit in opposition be filed positively on or before the next day, with a copy is served in advance to the legal counsel for this date of assent. Re-notify on after 4 weeks.
29-4.
I'm so obliged.
Item 13.
There is a delay of 49 days, lord.
You accept on behalf of you're appearing, no?
Yes. One is.
You're appearing for the department.
Yes, Lord, so I'm appearing for the
Because
current
of the
department.
delay. Delay for so-and-so supplemental litigant.
Obliged, Lord.
Appeal to be processed and preferably listed on. I have not appealed it.
11.
Lordship.
Obliged, Lord.
Item 14 for admission.
Yes, Mr. H.
Lordship, I have discussed with them and they have also deliberated on the thing. They have going to issue a fresh order. Approval of the minister is awaited. So a letter has come that 1 week's time may be given to us.
We give you 2 weeks.
Lordship.
You have
They have done a detailed exercise, but I don't think the results will be much different.
all of you are too busy.
But the department was, actually department was also, everybody is stationed in Silchar because of the prime minister.
Keep it after
The
2 weeks.
minister's signature could not be obtained.
Both of them can be accommodated if
It-
possible.
Not
Gauhati,
possible.
Though we would not have interfered, but since a single judge interfered, which caused instability to another.
Yes.
I think the better option is this. Because
We
they are-
have analyzed all their background. For how long, in which place they are stationed, and who are the other incumbents stationed in Silchar. There are total 5 posts. So they have done a detailed exercise and nothing will.
Both of them have equally strong case.
Absolutely.
Appellant on his
A
request,
strong as well as weak case also.
appellant on his request was transferred. Now,
Lord.
if it destabilizes somebody else, that should not be recalled.
Yes.
And the respondent is a lady. So she should not have been disturbed. Asking when her tenure was left. So just find out whatever is done.
Lord.
As prayed for on behalf of the state, re-notify 2 weeks.
Highly obliged.
31-3. Item 15.
Yes,
May I please, your lordship?
yes.
My lord, this is PIL, my lord, arising out of an action. My lord, and a school had been, my lord, introduced. My lord, for the purpose of, my lord, welfare and the benefit of minority and tribal people. My lord, after the construction is over, now this school, my lord, has been suddenly handed over to the university, my lord. And the main purpose has been defeated, my lord.
Why,
My lord,
who are the parties here?
my lord, the parties is the higher, is there, my lord.
But why? I think it's state of Assam.
Minority affairs is also a party, my lord.
Huh?
Minority affairs and is also a party, my lord.
Vice Chancellor, he has not reserved it.
My
I
lord.
think the correct body would be Commissioner Secretary, number 4, 5, and 6.
My lord.
Well, lordship, respond number 3 and 5, lordship, there is no push such like lordship.
Huh?
Respond number 3 and 5, lordship.
What?
The designation is represented by the Principal Secretary, Government of Education Department. There is no Principal Secretary of the Education Department.
State of Assam.
It should be lordship.
State of Assam.
Lordship, state of.
Don't take that objection.
Lordship.
Don't take that objection.
No, I am not, just I indicate lordship, even Director of Education Assam, whom I have to serve lordship.
Secondary is whole edition.
Mr. Gogoi, Mr. Gogoi, we don't expect you to take up this.
No, sure. Not.
You must,
Department is there, lordship, that is very good.
Respond. It's a
Lordship,
serious,
Lordship,
it's a serious matter.
Lordship.
We are not interested in passing the buck on the university. It's the state of Assam which is to answer.
Lordship.
David. This public interest litigation is directed against the decision of the authorities in unauthorizedly transferring the possession of Joy Model Residential School in Lakhimpur district, Assam, to the North Lakhimpur University beyond the mandate for which such school was set up. The Joy Model Residential School referred to above, according to the petitioner, is a fully constructed government school which was set up to provide free residential education from class 6 to class 12 with free boarding, food, uniforms, books for the purposes of all-round development of approximately 300 students from minority communities and economically weaker tribal families. The school is funded under the Pradhan Mantri Jan Vikas Karikram, a central government scheme run by the Ministry of Minority Affairs to create infrastructure in minority concentration areas. The construction of the school, which began in the year 2020, is complete. Which assertion stands certified by the executive engineer PWD. However, Mr. Bhuyan, learned advocate for the petitioner, submits that before the school could be inaugurated, at the instance of a local MLA, the building of the school was illegally taken control of and handed over to North Lakhimpur University without any specific government order in that regard. There appears to be no approval of the cabinet or any notification or perhaps permission from the Minority Affairs Ministry or Education Department. With the transfer of the building, the registrar of the university started using it for the purposes of running the university campus. A signboard was put up outside the building with the rubric North Lakhimpur University, Johin Campus, bracket proposed technology campus of NLU. The petitioner contends that this is the manifestation of the takeover of the building of the school by the North Lakhimpur University. The further contention of the petitioners is that the entreaties to that the complaints to the Director of Secondary Education and other authorities have fallen on deaf ears. This petition thus has been filed for a direction to immediately restore the building to its original contemplated use, contemplated purpose. And further direct for operationalizing the school by taking admissions of students for the next academic session. And further ensure that the infrastructure is used only for minority and tribal children as per the scheme under which the building was funded. Mr. Gogoi, Mr. K. Gogoi Leonard, advocate for the state, accepts notice on behalf of respondents number 3, 4, and 5, submits that he shall respond to the petition.
4 and 7, I accept notice.
Huh?
4 and 7, I accept notice. If yes, for the.
Mr. Sharma accepts
I'm
notice
for
on behalf of 4 and 7. Mr. Gogoi, you are appearing for Union of India also.
Lordship.
So you appear, Union of India does not have to respond here. Funding was made,
Lordship, I am.
construction completed.
Lordship.
Now, we want the state government to respond under what notification, what power, what
Well.
authority
Lordship.
has it been transferred?
I am for Lordship 3 and 6 also.
Whatever, notice that so Mr. Gogoi and Ms. Sumitra accepts notice on behalf of so-and-so. Response affidavit must be filed on or before the next day, 4 weeks.
Obliged.
5
Obliged.
weeks.
Obliged. Obliged.
Take the names and the parties.
6 May. Item 17.
Yes,
Yes, ma'am. In this matter, my lord, I am appear on behalf of 1, 2, 5, 6, 7, 8, 10, but we have not received any, my lord, memo of appeal, my lord.
no, but you have appeared on your own, no? No notice has been issued to you. Why would Mr. Katliar give a copy to you?
No, in fact, my lord, earlier there was a delay, in application that was condoned last date, my lord. Today, it has come for the first time, my lord.
Give a copy.
Yes, my lord, I'll provide a copy, my lord.
Copy of the memo of appeal to him.
My lord.
You people do not appear. Are you on caveat?
No, my lord.
And then
No, no, I may appear in condonation miss case, my lord.
you may have. You may have. But then here, unless we issue notice to you, what responsibility Mr. Katliar will have? Not make that complaint. And if you're here by filing a wakalatnama, obtain the copy of the appeal from the registry. It's a public document now. And so far as you are concerned, you are an important party. You will get one.
I'll serve a copy, my lord.
He will serve, but I'm at the maintainability of the objection raised by you.
I'm not objection.
If you're not objecting, then we'll ask them to give you a copy.
Yes,
Take
ma'am.
it.
But there is another problem is there, my lord. One person was already expired. Your lordship 2 times occasion, your lordship directed to him to
The person who is dead cannot be impeded. If he has been impeded,
substituted. I'm sorry for that. Substituted. Your lordship 2 times.
Otherwise, why? That is his choice. He doesn't want to impede.
Just that.
Mr. So-and-so. No, don't. I do not ask. Just to give me everything. Mr. So-and-so has appeared on behalf of the respondents, who submits that a response affidavit shall be filed by the next date. We notify so-and-so 4 weeks. Serve a copy of the memo.
Yes, madam.
Get up only when the order is passed. Huh?
8 May.
Obliged.
Item 18.
Yes, Mr. Chaudhary.
My philosopher. Second suspension, madam.
What is so bad about it?
No,
Suspension on 2 different grounds in 2
No,
different
not-
provisions.
my lord, you also kindly say 6(1)(c) and 6(2). 6(2) says if somebody is detained in custody 48 hours, etc. He is deemed suspension. So, and the charge sheet is to be submitted within 90 days. If not, then he is to be released. Accordingly, he was reinstated. This honorable court has set aside, my lord. Then again, the same case. And he was by the post, same investigation going on,
Doesn't it?
already trial also.
That was deemed suspension because of your having gone in custody. It's an ACB case.
Yes,
The second suspension is because the trial is pending and departmental proceeding is in contemplation of that.
it was idea, but prior to the release, prior to the reinstatement, already department proceeding started. Memorandum of charge already supplied.
Following Ajay Chaudhary, the single judge
Ajay-
pushed the suspension order.
Ajay Chaudhary, my lord, actually, there is only normal suspension, my lord. Here, what is there, my lord? You will kindly see imprint order, my lord. Just back to your lordship to take that imprint order.
Mr. Chaudhary, you answer us, and we are taking you to the last part of the order.
Page,
Which if you say, we can remove this. Be that as it may, liberty is given to the petitioner to oppose this court in the circumstances of such suspension order is extended beyond a period of 90 days on the grounds of its reasonability and rationality. Now, this also is unnecessary. We will delete this from the order and we will modify the order to the extent that you do whatever. We are not here to advise you.
My only question, my lord, that is given 190. My whole question is, my lord, whether that second, that law is to be settled, my lord, because
Law is settled.
law is to be settled, my lord.
We settle it now because it is already settled.
So then now kindly see, my lord, what the one single just said, my lord, your lordship kindly see. Just I take your lordship to page 59. Page 59, paragraph 10. Paragraph 10, my lord. Paragraph 10, page 59. It further appears from the materials in record, more particularly the documents which are kept on record and marked with letter so and so, that in the meantime, the memorandum of charge has been served upon the petitioner and the Department of Inquiry proceeding has been initiated. This initiation was made prior to the order of this honorable court, my lord. It is not subsequent to my lord. Learners singular say, in the meantime, charge sheet file, so.
That's a factual error.
So,
Gets you nowhere.
no, my lord, question of why is involved if it is initiated.
Suppose-
Investigation is going on.
Suppose we put this paragraph 10 under eclipse. Would the situation change?
Then question will come by the investigation. That was also investigation stage when my idea was set aside, my lord.
Where a case against him in respect of any criminal offense is under investigation, inquiry or trial.
Correct.
Correct?
Right.
So this is provided under 6(1)(c) of the rules of 1964.
True, my lord, true.
Provided that where the order of suspension is made by an authority lower than this.
Yeah, I do
doesn't
not fall
concern
under
us.
that.
So therefore, this is a standalone provision. And because you have been subjected to a departmental proceeding and a criminal case, you should have come up for another thing that one should be stayed till the other is completed. You will have to open your cards at two different places simultaneously. The law which gives you that leeway, Captain Paul H. Anthony and other cases, even Karunakar, you go for this. Second suspension shall continue. It is within the powers of the disciplinary authority.
But if I correctly understand, my lord, if the subject what you always say, my lord. What I mean to say, my lord, that so far C is concerned, 6(1)(c). It's concerned normal, my lord. It is a fresh case. Suppose somebody is serving, my lord.
Say so, show us a judgment.
So in investigation, no, this itself shows, my lord. This provision itself says, my lord.
Provision, we read it differently. You are reading with a very.
But once
wide
provision is
approach.
unambiguous, my lord, whether it needs interpretation or not, my lord. If your lordship satisfies the interpretation that provision is unambiguous.
You have a ground there. You have an arguable point that this concerns the same lodging of the FIR in which I was taken into custody. Therefore, this would be deemed to be second suspension, which may not be permissible. We see it with a smaller aperture, smaller lens. We say that was deemed suspension. This is purposive suspension.
But here is a case, my lord.
Show us a law.
One now, Ajay Chaudhary, suppose Ajay Chaudhary, my lord. Ajay Chaudhary.
Chaudhary
So Ajay Chaudhary says, my lord, it's normal one.
advantage.
Yeah.
And rightly so,
Ah.
of Ajay Chaudhary, and your suspension was caused because charge sheet or charge memo was not forthcoming.
Yes.
Correct. The law is there, statutory law and judgment law, both.
So this being investigation, this was also there, my lord, when my suspension was set aside.
Yes, for the state.
That is one day I'm concerned, my lord.
Now, his slender ground is that this suspension also relates back to the same offense,
Same offense.
same inquiry,
Same investigation.
in connection with which he was arrested under and suspended under which provision?
Idea 6(2) and now 6(1)(c).
6(2).
Yes.
And now, can it now be invoked by taking resort to provision under 6(1)(c). Unless you have a special reason to say that he is causing impediment in the free flow of the departmental proceeding, or is trying to intimidate witnesses, or trying to garner support from the witnesses, unless you say that, this is his ground. We don't read it so widely. For the reason that he's facing prosecution for corruption.
I'll take instructions.
Take instructions and tell us, Mr. Chaudhary, you don't have any law to support your submission.
I'll see my
We
lord.
decide, we
But
decide.
only, yeah,
अभी ना question. क्या respond करेंगे? फिर बताएंगे. We did not make the research on those we were found. Taylor. The appellant.
the last part also you was in note, my lord, that 90 liberty. That part.
That we will delete. That is an unnecessary advantage to you, which you have not earned.
Yes, sir, that is.
Nothing. But we are not interfering with the order of suspension. Since you have raised a question of law, let us frame it and let us answer it. If we start using a very restrictive logic, perhaps your case needs to be dismissed today outright.
But the
But
question,
let's see.
but the question which I think, my lord, because
Question you
Same-
have formulated to our satisfaction.
my lord,
then
charge sheet file, inquiry,
Question you have not formulated to our satisfaction. Let us see whether we can formulate it for our.
now, Ojoy Chaudhary, let us see now, my lord, Ojoy Chaudhary already done, I got a relief under Ojoy Chaudhary, my lord.
Chaudhary, लिखाने दीजिए. Let the court dictate the order. We are not closing it today.
No, I'm not, just I'm saying, my lord, your lordship kindly see difference between 6(1)(c) and 6(2), my lord. Quite two things, but same investigation,
We are not able to see any difference, but let's see.
and I give to your lordship.
Let's see. The appellant was suspended for the reason of his having been arrested in connection with ACB PS case number 47 of 2024. In terms of Rule 6(2) of Assam Service bracket Discipline and Appeal Rules 1964. Bracket hereinafter referred to as Rules of 1964. Next pan. Rule 6(2) of the Rules of 1964 provides that a government servant who is detained in custody, whether on a criminal charge or otherwise, for a period exceeding 48 hours, shall be deemed to have been suspended with effect from the date of such detention, by an order of the appointing authority, and shall remain under suspension until further orders. There is an exception provided in 6(2), in Rule 6(2), that where the detention is made on account of any charge not connected with his position as a government servant, or continuance in office, or his continuance in office is not likely to embarrass the government or the government servant in the discharge of his duties, or the charge does not involve moral turpitude, the appointing authority might choose to vacate the suspension order made or deemed to have been made when he is released on bail or is not otherwise in custody or imprisonment. This suspension of the appellant continued for 90 days without framing of charges against him, without the memo of charges having been framed against the appellant. The learned single judge in that instance, basing his opinion on the judgment of the Supreme Court in Ajay Kumar Chaudhary versus Union of India and another, 2015, 7 SCC 291, and Rafet Ali Ahmed versus State of Assam and others, 2023, bracket 3, GLT 718, quashed the suspension by order dated
Page 39.
26/5/2025, passed in WPC number 659 of 2025. First up, the appellant was reinstated. First up, however, shortly thereafter, however, 6 months later, the appellant was reinstated by an order dated 9/6/2025. Next paragraph. However, 6 months later, he was again placed under suspension. And this time, under the purported exercise of power under Rule 61C of the Rules of 1964. Rule 61C of the Rules of 1964 provide that an employee could be suspended where a case against him in respect of any criminal offense the 61C provides that an appointing authority or any authority to which it is subordinate or any other authority empowered by the governor in that behalf may place a government servant under suspension where a case against him in respect of any criminal offense is under investigation, inquiry, or trial. He could also be suspended where a disciplinary proceeding against him is contemplated or is pending. Or if in the opinion of the authority, the employee has engaged himself in activities prejudicial to the interest or the security of the state. Mr. H.R.A. Chaudhary, learned senior advocate, submits that though the power under section 6, under rule 6, could be invoked under 3 circumstances, namely, if the disciplinary proceeding against an employee is either contemplated or is pending, or the employee has behaved in a manner which is prejudicial to the interest or the security of the state, or where any criminal case against him is under investigation, inquiry, or trial. But in the present case, his suspension tantamounts to second suspension, which is impermissible, for the reason that this suspension order under 61C is for the same case for which he was arrested and was considered to be deemed suspended under Rule 6(2), which suspension order was terminated under the orders of this court for no charge sheet having been framed against him for 90 days. So thus, for all practical purposes, the second order of suspending the appellant is vindictive, especially when it relates to the same offense for which he was arrested. Though Ms. Sumitra Sharma, learned counsel for the state, contends that the so-called second suspension of the appellant is under a different standalone provision and cannot be conflated with the power exercised for deemed suspension of the appellant on his arrest and being kept in custody for more than 48 hours. But how did I begin? Contents. But submits that a detailed affidavit shall be filed in this regard by the next date. Re-notify also. We are not convinced, but then we have raised an issue, let it be answered.
Respondent number one, Mr. Nayak's name, the additional advocate general's name. Maybe.
Let's simply notice, no, these petty things, we don't ask us to include in the order. Do we say that a prayer for interim relief rejected? You're not making an interim prayer.
Interim term is there, we file separate petition.
The prayer for the prayer for interim relief is, however, rejected.
Always. And date, my lord.
29/4.
Without date, no order would be passed. That is for sure.
Let us see, my lord. Obliged, Lord.
Let us see. We have given a standing instructions that when we adjourn a matter, for whatever reason, date is given. Otherwise, it remains undated. This request I have made to the other courts also, other judges also.
Obliged.
Yes.
Item 19.
Let bank be noticed. Who appears for the bank?
My friend is there, my lord.
Yeah, take instructions and tell us.
Yes.
Otherwise, this goes before DRT.
It's your lordship, Balakrishna early judgment is very clear and correct.
It's factual. I mean, it was asked some one-time settlement. Are you agreeable? You want money or you want litigation?
Sorry, I'm not in.
Are we not aware of Satyavati Tandon and other things?
No. Sorry.
We normally don't interfere in such matters. We ask the parties to go to tribunal or appellate tribunal.
Yes, sir.
But
But
if
your
you
lordship,
can settle, you can take instructions, come
Right.
back after a week. We are not passing any interim order here.
yes. But
Mr.
your lordship,
Counsel, you
no,
have
yes,
many-
proposal.
Many a times you stand there, still you take this. Many a times you stand this side, still you take this unnecessarily relief.
No, your lordship, I always used to appear for the bank.
Next time that you come before us with a prayer that district magistrate should comply under section 13(4), we'll say no. We'll not even ask the state council to do that. Take a reasonable view of the matter. Take a, Mr.
But your lordship, I think they have not filed any OTS proposal.
Yes, that is there, that we have on page 39.
Mr. M. Sharma, appearing for the respondent Indian Bank, submits that he shall take instructions to the matter and report to this court whether there is any possibility of agreeing to the proposal of one-time settlement of the petitioner who is facing surfacing.
No.
Re-notify 2 weeks.
May I make one prayer, my lord? My lord, since till then, my lord, no coercive action.
Sorry.
Because, my lord, they are, my lord.
Nothing. We know our limitations. We
That's
know our
correct.
remit. This is just to cut short the matter in
Yes,
case the
yes.
bank would request
That's
money to be clawed back
Madam,
and not spend money on litigation. That therefore we give this opportunity, but this is beyond our remit.
one more submission, my lord.
No.
Not on the stay, my lord, one more submission, my lord.
No
My-
interim.
No, my challenge was in this petition is that, my lord, 12/1/2026 order passed by the district magistrate, my lord, that without taking an affidavit, what is mandated under securitization section 14.
Go before DRT. The moment you raise all that, go before DRT.
My lord, section
Don't
14,
bother us.
section 14 order is final, my lord.
Mr.
That's
Das,
yes, my lord.
Mr. Das, we have
Without it.
My lord, section 14 says this order is final, my lord.
let us see.
Yes, sir. Obliged.
2nd April. Item 20.
Make prisoner. So this is a PIL pertaining to the Silpufri area. There's a park there.
Just. Yes, Mr. Saikia.
Lordship, I'll obtain the instruction, Lordship.
20% work is done.
Definitely, not left.
Work left. That can be completed.
Yes, Lordship. So I'll bring instructions and I don't think it is adversarial.
Nah.
implementation.
No,
Not at all.
you're interested in beautification and
It left, I do not know.
you are interested in beautification and landscaping
Lordship.
because for that you spend money. You're not going to waste that.
It's a small work, Lordship. There is a pond, very historical value.
So you waste that expenses which you have already paid.
Lordship.
Take it. Okay. We have
One small prayer, there's an interim prayer that if my learned friend said, if they can submit a status report as to by when this can be done, if at all.
We are not having no confidence
Fine.
on
Obliged. I'm
Mr.
okay.
HE's assurance that it shall be done.
I'm okay.
Don't ask us to lay bare everything what is being done and question the why this is not being done. Then it becomes adversarial.
Fine.
No, he has,
Just
of
small
his own, he has said
Okay.
that we are not asking him for anything. We are only asking him to just provide what is happening, why is that it has been installed, if at all it has been installed, and whether there could be a possibility of completing it and opening it to the public. That's
At
all.
the earliest, Lordship. Had it been 1 month earlier,
It
we would
would
have
have
done it before the notification.
So why is status reported
Fine.
on that?
Obliged.
Take them. Otherwise, you had not asked for beautification and landscaping. It was their decision.
Yes.
They have spent
Yes.
money,
Yes,
80% of
yes,
the work
yes.
is done.
The
Jahan par
bridge was already open here, the bridge which was just adjacent to it.
Take it. Wherever it is required, we hit hard the state. Where it is not required, it means nothing. Take it. We have heard so and so. We have heard Mr. D.K. Bhattacharya, learned advocate for the petitioner, and the learned advocate general for the state of Assam. This petition concerns reopening of Silpokri Park, which was closed for beautification and landscaping makeover. So the contention of the petitioner is that despite 80% of the work having been completed, the park has not been opened. And there is an inexplicable abandonment of the project, making it 100% complete in all respects before being open to public at large. The petition also mirrors the historical importance of the pond, which is said to have been dug during Ahom King Raja Rajeshwar Singha. It has a water reservoir and served as a heritage site for a long time. It is considered to be green lung in one of the most crowded parts of the city of Gauhati. A writ petition earlier had been filed by WPC 1787 of 2009, which led to some repairs of the pond. And the pond in its present avatar was inaugurated on 1st of November 2010, which served as the relaxing place for senior citizens, children, women, morning walkers, etc. It was only about 2 years ago that the government took a call of further beautifying the pond area by constructing, by making, by landscaping makeover. But thereafter, it has remained close to the public. It has remained close to the public. The learned advocate general submits that he would need to take stock of the situation and report to the court as to why the work was stopped midway. The work was stopped at a point when only 20% of the proposed work was to be completed. So he further submits that if there are no insurmountable impediments, there would be no reason to delay the completion of the beautification project and opening it to the public. Awaiting the statement of the learned advocate, instructions in the matter. This case is adjourned after 4 weeks.
Obliged. Highly obliged.
27-4. Item 22.
Somebody wanted time. You wanted time, no?
My lord, actually, there was a mistake, my lord. The impugn order dated 28/1/26 has been enclosed in the top of the writ appeal, but in between it is not enclosed. So if your lordship kindly permits me, I will argue. Otherwise, I am ready.
No, why not? I didn't follow. What is the objection? I mean, you
Yes. My lord,
why you not argue?
Impugn order is 28/1/2026.
yes, 28/1/26. Yes. My lord, we have assailed this order because, my lord, the many persons in the year 1991 were appointed as my lord staff nurse. In the top of the, my lord. Impugn order is in the top.
Let us see the order. That is not what the law says. Yes, what do you have to say? Are you, Mr. Mahmood?
My lord.
Don't tell us the facts. You say on what legal point the judge has erred. If you can say, otherwise we are inclined to issue notice, Mr. Sarma will have to respond.
That will do.
No, but you have filed a the appeal, you tell us what
And
is
then,
your
my lord,
understanding.
in the year
What is
19,
your understanding? Our understanding
my
is that this
stand is,
constitution is wrong.
my case is this, my lord.
The
In the
difference-
year,
Why did you lose that case before the elected single judge?
yes,
We find that because of your unnecessary referencing
delay.
Mira Saikia, no, Mira Saikia, you have spoiled your case. Perhaps the judge took it to be a challenge to the promotion, an out of turn promotion of Mira Saikia.
Absolutely, that was not our prayer.
This may not have been your prayer, but the way you proceeded with the argument, this was the
We have
perception.
clearly mentioned in our writ petition that we have no grievance against Miss Meera Saikia. But we only want that the benefits which have been given to her, that should be given to me, because on the same day, by same appointment letter, both of us were appointed, including many others. Including many others, my lord. And my position was in the top than her. Then she was promoted to the post of ward sister. My case was not considered. Then she was promoted to the post of assistant matron. My case was not considered. So this came to me much later, which I have clearly mentioned in para 5 to 10 of the writ petition, that it came to me later on when I came to know my contemporaries have been already promoted to ward sister and then assistant matron. Then I'll file a representation before the authority. Authority kept total silence. So having no alternative, I have approached the Honorable High Court for remedy. Remedy was that what benefit has been given to my contemporary or my juniors, that should be given, and I have the support of so many judgments. I have the support of so many judgments of the Honorable Apex Court, where it is said that if the juniors or the contemporaries are promoted, then
Therefore, you made a wrong argument, you lost the case. That was a wrong argument. The person that you have referenced in all your submissions, right from first line to the last line, is Mira. Mira Saikia. Mira Saikia has
no,
retired.
I have taken only one person as for an example, my lord.
So you should say that this is the example, this is a clear example, manifestation of the hostility towards me. Deliberately or inadvertently. So therefore, I must be compensated. It should be backdated, the promotion, and I should be given the notional benefits. Simple. And then you should have argued that it is a continuing wrong, therefore 13 years should not be taken as an impediment. You argued something else and you are blaming the court.
I leave it to God.
So you are arguing the same thing. Therefore, we said that you argue the same thing, we dismiss the appeal. But allow us to formulate the point for you. Then Mr. Sharma will answer.
Well, I leave to your lordship.
Yes.
Well, I am sufferer.
You are, you are sufferer. Let's see. We have heard Mr. Not Sharma, sorry. We have heard Mr. M.V. Mahmood. M.U. Mahmood. M.U. Mahmood, learned counsel for the appellant. And Mr. D.P. Bora. Why I was calling you Sharma. Learned, and Mr. D.P. Bora, standing counsel health. The appellant is a long-serving nurse in Assam Health Department. She was appointed as a staff nurse on 26th of September 1991 at Civil Hospital, Gauhati, along with many others, including her colleague, Srimati Mira Saikia, who stood junior to her in the merit list. However, over a period of time, she could not be promoted on time, whereas Mira Saikia was promoted to the higher post much before. When this was discerned by the appellant, he approached this court by WPC 5929 of 2023, which writ petition was dismissed on the grounds of laches and delay, which was primarily dismissed on the grounds of laches and delay. The learned single judge observed that it is a settled position of law that in the event of an employee having a grievance with regard to promotions effected in respect of another employee, while his own case for such promotion was not considered, is required to assail such promotion within a reasonable period of time. So in this context, the factual position was analyzed that the promotion of the appellant was effected on 8/11/2019 to the cadre of ward sister, while in the case of Meera Saikia, promotion was given to her with effect from 22nd of January 2010.
8 to 10.
22nd of January 2010. Since the writ petition was preferred by the appellant only on 4/10/2023, that is after 13 years, with effect from the date when Meera Saikia was so promoted, and perhaps after 4 years from the date when the appellant himself was promoted, the court, the learned single judge, was loath in interfering with the same. Mr. Mahmood, learned advocate for the appellant, however, submits that the learned single judge perhaps mistook the reference to Meera Saikia as a challenge to her promotion, which was not the case. The reference to the case of Meera Saikia was only made to demonstrate that the appellant also required to be considered for promotion sometimes in 2010, which was granted to her without any explicable reason only in the year 2019. It was under such circumstances that the appellant had prayed for notional promotion from an anterior date with monetary benefits. The further contention of Mr. Mahmood is that the issue relates to refixation of pension, the issue relates to refixation of the date of promotion, which remains unrelated, which presently remains unrelated to the seniority issue affecting the third party. This delayed promotion, therefore, ought to have been considered to be a continuing wrong, where the delay ought not to have been, the delay in approaching the court ought not to have been taken a reason for dismissing the writ petition, In Union of India and others versus Tarsem Singh, 2008, 8 SCC 648. The Supreme Court has laid down the principles underlying continuing wrongs and recurring/successive wrongs, and applying the same to the service law disputes. A continuing wrong refers to a single wrongful act which causes a continuing injury. Recurring or successive wrongs are those which occur periodically, each wrong giving rise to a distinct and separate cause of action. in Balakrishna S.P. Wagmare versus Sri Dhyaneshwar Maharaj Sansthan, AIR 1959, SC 798. It was observed that it is the very essence of a continuing wrong, that it is an act which creates a continuing source of injury and renders the doer of an act responsible and liable for the continuance of the said injury. If the wrongful act causes an injury which is complete, then there is no continuing wrong, even though the damage resulting from the act may continue. However, if a wrongful act is of such a character that the injury caused by it itself continues, then the act constitutes a continuing wrong. Continuing wrong. Stop. Next, true it is that a court cannot be faulted for not permitting a belated resort to the extraordinary remedy under Article 226 of the Constitution, for the reason of entertaining such petition might result in creating confusion and public inconvenience, and it might bring in its train new injustices. But where a service-related claim is based on a continuing wrong, there have been instances and precedents of relief having been granted despite the delay in seeking remedy, if it does not affect others, or if the reopening of the issue would not affect the settled rights of the third parties. In the present case, Mr. Mahmood argues that nobody, including Meera Saikia, who is now retired, would be inconvenienced or put to any difficulty if the issue had been reopened by the learned civil judge, and the claim of the appellant would have been considered that the entitlement to promotion in the year 2010, her entitlement to promotion in the year 2010 was bypassed for no good reason. Reopening the issue would only have amounted to refixation or payment of arrears of the enhanced salary or promotion, which also could have been considered in view of the judgment of the Supreme Court in Tarsem Singh Supra, namely limiting it to 3 years from the date when the issue is reopened. Mr. Bora, learned government council, learned standing council, so and so. It's only on delay. Now, there is not going to be any inconvenience to a third party. Therefore, the issue had to be decided, no? Only because 13 years throw the file, this cannot be done. केवल delay पर उड़ा दिया, ऐसे तो नहीं होता ना. So you must say, and therefore we have given you that limited window. You will not have to pay the change salary for 10 years.
Yes, my lord.
It's only for 3 years. Tarsem Singh. Tarsem Singh is something which has not been disputed up till now, since 2008.
But my lord, repetition may also create problem because there may be some other persons also. my lord.
That is not the third party. Some other person we don't know. As and when they come. इनका क्यों right खराब कर दें? He has approached here.
My lord, if maybe that my lord.
Call we will decide.
Yes, my lord.
We are not closing it today.
Yes, my lord.
Mr. Bora Leonard, government advocate, admits that he shall respond to the appeal by the next date by filing a requisite affidavit. Let such an affidavit be filed positively by the next date, 4 weeks. Chalo, next. Mr. Mahmood.
My lord,
This is the way you have to formulate your relief.
actually, my lord, I have also brought some
Your
citations.
case will not be considered. Abhi, still today also you were arguing about Mira Saikya.
Highly
Make a reference. And then when you are being questioned for delay, you tell the court or tell me, tell whichever court you appear before, that delay in all cases may not be the end point.
Yes. I have also got some those citations.
Citations, if you keep in your file, it is not going to help. No, you have to argue, no? Yes.
Obliged. Highly obliged.
May I please, Lordships? So the order is at page 84, madam.
Yes.
My lord, by this order, my lord, we have been given liberty, my lord, to challenge an order dated 15/5/2025.
Termination of release.
No, my lord, that is not a termination order. In fact, the order.
Why did you not resist? Why did you not?
Well, because we are not given any opportunity, my lord.
Mr. Counsel, the difficulty is that if you raise this point, then we ask you to go for review. Question that we ask.
But none of the issues are gone into, my lord. This is
right. So therefore, ideal case for review.
That
show your memo, show your petition. Say that perhaps there was some misunderstanding. Let you decide again. Withdraw this petition, go for review.
My lord, lordship thesis, my lord.
That's your only. That's
I
the anchor.
I understand, my lord.
Otherwise, the object is clear. But why don't you file a petition that way? Why do we interfere? Challenge the termination, but there is no termination.
This is not a termination order at all.
You have to go for review.
Because what has happened, this order was already complied with.
After some arguments, Mr. M. Datta, learned counsel for the appellant, seeks permission to withdraw this appeal in order to file a review petition before the learned single judge who has passed the order reviewed on the ground that there has yet not been any termination of lease of termination of the mining lease of the appellant. Dismissed, withdrawn with the liberty of aforesaid.
Item 24.
Wait, please, my lords.
Yes, just a minute. This is item number
24.
Yeah.
My lords, the petitioners before your lordship, they are headmasters in charge for the last 2.5 years. And now for regular headmasters, a process is going on for filling up the post of regular headmaster. So we are not even within the zone of consideration. So first of all, the first line in which we have
you have to cross.
Yes. So the first line is that a gradation list is to be published every year. So the gradation list is not published, first of all. So that's a violation. So for that, I could have gone to the single judge also. So that is the first thing. So if I am within
the zone of consideration, then perhaps I do not need to go to the next level. That's one. And secondly, rule 14, sub-rule 1 and 3, I have challenged. So that's it.
That you cannot.
Yes.
That you cannot now because of the first ground that you have not reached that threshold. We would not have a rule questioned by somebody who is not benefiting from it. By this rule, if you are benefited, if 14 goes, you are benefited, we will permit you. Yeah, I'm very happy that you have understood your case so well so as to tell about it in the beginning. You're right. So, therefore, instead of challenging rule 14, which will be an uphill task for you, because this is in the domain of the rule making authority.
Yes.
This does not prima facie appear to be arbitrary. Does not prima facie appear to be arbitrary. So before we interfere, we would think twice. So the better option for you is to approach the learned single judge and ask him for a direction that gradation list should be published. Suppose even with 14 gone, or 14 having been read down, if you don't fall in that category, what is the benefit of contesting this petition?
No, Lordship.
You must have understood.
Yes.
Because the way you have approached this court, I think you have understood your limitations.
Yes.
The better option is this, because now read rule 14. How do you say that it is bad in any manner? Rule 14 of which rule?
This Assam Secondary Education Provincialized School Rule
2018.
2018.
Have you quoted it in your petition? You have a copy of the rules?
It is there, Lordship.
Oh, it is there, so that is all right, but
page 35.
Rule 14 says what?
Yes. Now, as the rule stands today, a classification, because Rule 12 talks about appointment of principals in higher secondary schools, and 14 talks about promotion to the post of headmasters in high schools.
Have you decided this matter in any other case?
It's pending, I think. The same challenge is pending in some other.
Lordship, verify, Lordship, I'll verify.
Where is Mr. Khatmiar?
He will not remember. He is there. No, we were talking about eligibility. He says something else. 10 years of experience, 5 years of experience. Now, have we ever dealt with this 2018 rules and section rule 14?
This is similar to item number 37, which has been mentioned to the morning, my lord.
Adjourned.
Yes, my lord.
Mr. Chaudhary had also appeared.
Yes, my lord.
इसमें कौन सा date दिया 37? 27. But then you would say that the process is ongoing. You can't wait till 27/4.
Yes.
But then we are not doing it.
But it was also same case. The process was going.
Yes.
You had not passed any interim order.
There was no interim order in that case.
Here, let this case be listed along with WPC number 2617 of 2025, which is slated to be listed on 27/4.
And Lordship, just one thing I wanted to point out is that here, first of all, it talks about as per seniority. Promotion will be as per seniority. But 14.3 says.
Claim is absolutely different.
Yes.
With some stroke of luck, you became in charge principal, you want to be given weightage.
Yes.
So this is not in our authority. So if you press that, we need not even press it, we'll dismiss your petition.
Lordship, I'm not going to that. The only thing is 14.3 says that there has to be an interview. There shall be an interview. So if only seniority, then why interview?
Says what kind of you started with such good perception of law. What is this? It is seniority come merit always. Does seniority come merit mean that no merit has not to be seen? Don't know the law which is evolved, that this is only in the domain and this cannot be done away with. Why interview? Do you mean to say that seniority, howsoever tougher you are, you would be, since you have joined early, you will get weightage? No.
Lordship, I am
Seniority
saying,
come merit is
yes,
that if both the persons, senior and junior, are above the threshold, seniority will weigh. That is the law. Merit comes seniority and seniority come merit. Very subtle distinction. Both operate somewhere. The downline is merit, somewhere the downline is seniority. Can't take this plea. If you don't want to have it tagged with that, we'll decide it.
no, let it be, Lordship. Maybe I can come up with
All right.
something.
Yes.
Item 25.
Yes.
Lordship. Our father died, your lordship, thereafter.
Please don't say father died, your financial circumstances. We are not here.
That is not a
What
question,
do you
lordship.
Bank of Baroda?
Purportedly, my,
Counsel for Bank of Baroda. Mr. Counsel, please answer.
there is no,
We are giving you a lease of life. You are arguing it will be dismissed straight away. Go before DRT. Let notice be issued. It's very difficult to interfere in such matters.
because your lordship,
Sarfezi, we
Yeah.
remember Satyavati Tandon even today. They say keep your hands off.
there is a partition case going on a,
What do you call this? Are we court of facts?
lordship. The bank could not have issued a subsidy notice, your lordship.
नोटिस करता हूँ कुछ कर सकते हैं तो करेंगे
The loan account, your lordship, that has been,
Somehow we want to issue a short notice to the bank, nothing more than that. And our view is that this, we cannot entertain this.
बात समझिए.
Even if partition, that can be decided at that
Even
point
your
of time by the district
Partition issue, partition issue, and this fact we will decide.
they have participated in the civil case, your lordship.
So that we understand. At the time of possession, that will be seen by the district magistrate.
However, your lordship, they could not have issued a notice in a regular account, your lordship. The account must have been
ये भी DRT.
NPA.
This also is a subject matter of DRT. You withdraw this, go before DRT.
Lordship, I issue notice, your lordship.
फिर आप क्यों बहस कर रहे हैं? क्यों बहस?
No, just apprising, your lordship.
Uprising. नहीं, let notice be issued. Just let notice be issued. ऐसा लिखो. The petitioner, a co-owner of the property in question, has challenged the aggressive recovery action by the Bank of Baroda under the Sarfezi Act of 2002. The land in question is a jointly owned property in which the petitioner has a 1/4 undivided share after the death of his father in 2019. It appears that in the year 2024, a notice was issued to the petitioner in his capacity as a guarantor for a loan allegedly taken by one of his brothers, Subodh Kumar Shah. The petitioner denies of ever having become a guarantor to any loan and alleges that his brother / Subodh forced his father's signature to mortgage the entire family property without consent. The petitioner had filed a FIR against his brother for fraud. And also apprised the respondent Bank of Baroda about the issue. So despite this, the bank has persisted with SARFAESI proceedings and has issued notice for possession of the property and symbolic possession. A partition suit also has been filed by the petitioner seeking to divide the property equally amongst his brothers. In that partition suit, the bank has been added as a defendant. The bank itself filed an application to be added as defendant.
No, sir.
No. The bank intervened. The Bank of Baroda, the respondent / Bank of Baroda intervened by getting itself added as a defendant in the suit. The general objection of the petitioner is that the mortgage itself is fraudulent and invalid, and he had never been a guarantor of any loan. There is yet another aspect of the matter which has been highlighted by the petitioner. In the proceeding under Section 14 of the SARFAESI Act 2012, the respondent bank had admitted that the loan was regular and that has not turned bad. Thus not necessitating an emergent recovery action under the SARFAESI Act. Let notice be issued to the Bank of Baroda on steps being taken by the petitioner within a period of 2 weeks. 2 weeks, both modes returnable 6 weeks. No interim order, nothing. This also is beyond our remit because you appear to be a person who is, who has never guaranteed. We do not know. You have filed the FIR to shield yourself. Maybe you would be an accused. We don't know. But in fact, the best option for this court is to reject this altogether, ask you to go before DRT. And therefore, we said that we are issuing notice to the bank. We insisted on argument.
11th May.
We'll get back in 5 minutes. Yes.
Item 26.
Lordship, in this case, Lordship directed me to place the case numbers regarding pendency of the similar issues before this honorable court.
Is it pending?
Yes, there's around 8 numbers of cases, Lordship.
8 number of cases pending before us.
Serious case, Lordship, regarding that issue of what was the learned industrial tribunal.
Okay. And how come we are not comfortable with the order of the learned single judge making alterations with the award?
Lordship,
that can't be done, no? You may not be happy with this. You may not be happy with this. He would be happy with this observation. But let's keep it. When is it listed? This has to be.
Lordship, the date not fixed, Lordship. Last order, it seems.
We'll fix a date. No? How many cases are there?
8, around 8, Lordship.
Around you have given us the number of all 8.
Yes, all the cases.
Okay.
But it's a difficult proposition. I cannot take up this matter. WA 167, my judgment.
Oh.
That is very intra-court appeal is different. This intra-court appeal will definitely. The only difference is that against the award, either the award can application, either the award can be rejected. Or it has to be accepted. There cannot be any alteration
Of modification motion.
That is my view, tentative view, but let's see. Okay. Let's just. Sure, one point that we have to explore. Or if you want this bench to continue to hear this matter, we decide it independently.
My lord, it can be done, my lord.
It can be done lawfully. Only I have appraised that issue is pending before the honorable court. That is my duty to appraise. Issue is whether intra-court appeal will lie or not.
Court, we are not bothered. We are on the issue of any alteration in
That is there,
in
lost
the
that.
award of the trial, like arbitration.
Yes, look. Either it ought to be set aside or it will benefit.
Intra-court appeal, I don't think that this does not pertain to anything under 227. If we consider it to be an order passed under 227, then no interest.
Consider that is taken.
What is the ground that you have taken? Mirajkar's judgment 9 judgment?
Here I am respondent. I am
No,
respondent.
what was the point taken by the learned civil judge?
Anything recorded in that order?
Regarding-
I am aware that it was hard for almost a month continuous.
That 227. On in respect, I've checked in respect of reticle number 152 of 24. If your lordship checks the order dated 24.
No, but that issue.
His honorable division bench has presumed that the order passed by the landed single judge was order passed under Article 227.
So which order? In which
Reticle number 152 of 2024.
WPC 4839 key record.
152.
Yeah.
Order dated?
24.
Is the writ record?
21, 28, 124. 152. WA. WA. Uh, 124. Reticle 152. Twenty-eight, 10, 24.
This issue will confront us. Okay, let this appeal be listed along with equipment mentioned like that. Listed along with WA number 152 of 2024 and 7 other analogous appeals. On 23rd of April. On 23rd of April. Sure.
That is true.
On 24th of April, under the heading hearing. Has it been admitted? Ajay, under the appropriate heading.
Standard. Applies, madam.
Item 27.
Yes,
May I please, we require 3 weeks time to file our response manual.
yes, last time Mr. Chaudhary had a.
Yes, manual, on behalf of him and,
Time.
yes, sir. Last time we given them.
Nurse reflecting subsidies. Anyway, again. Was a guy.
Yes.
Learned council for the state. Learned council for the Union of India. Submits. Yeah, the response affidavit. As the response affidavit shall be filed on or before the next date. Where adjournment has been made. On that account. Let this matter be listed. Let this appeal be listed. For final determination.
22nd or 23rd, my lord, April.
22nd of April.
Awesome.
That suits you. That date suits you.
Yes. After
You come from which place?
I'm from Pingshuki.
22nd of.
I'm grateful.
Item 28.
Yes, Mr. Gogoi.
My lord, I pray for further 2 months' time, my lord. The verification of the claim for, my lord, that amount of 900 per month. That is under, my lord,
Big
scrutiny. My lord,
basic salary.
I
It is
understand.
lower
My
than.
lord, there are several claims, my lord. In the present petition, it's about 240 petitioners from 7 districts.
You can't make them starve.
My lord.
You not feel good with your state seeing starving nurses. You don't dispute that they were employed.
No, they were honorary workers, my lord.
They are
Discontinued in December 2012. Central share and state share. 900 rupees, my lord, was enhanced to 900.
Livelihood to the first preference then.
Lots.
We are not asking you to make them regular or something.
Lots.
But whatever is due to them, areas of
Yes, sir.
salary.
They are verifying, my lord. Also will give us some time, my lord.
At the request of Mr. B. Gogoi, when additional additional says the matter is adjourned, give a date in May 8. You look at these nurses, they're petty among them. Of course, the number is big, but then they're not asking for more.
Lots.
Only that. Or we feel bad when they are not paid. Any person earning less than 25,000-30,000 rupees, if he is not paid, consider his how would his kitchen run.
Get me. Item 29.
In this case, I am praying for a slight accommodation, Lordship. I am not fully prepared with this case.
We'll grant you. Let's put it after election.
Maybe if there is urgency, day after tomorrow, after vacation, it will be best.
Urgency must have in the May Chaudhary. Legalization में क्या urgency है?
We have been waiting for a pretty long time.
So you can wait till May.
Your Lordship will, I'm perfectly fine with the accommodation, but if I can pray for an early date.
April. We give you an early date immediately after Bihu holidays.
23rd or 24th, Lordship.
23rd or 24th.
I think many others that's there.
And as prayed for by the learned AG, let this matter be listed on the 3rd of April. You see this one?
Item 30 to 36.
My lord, this item number 30 is concerned, my lord, is the promoter, my lord, PIL regarding, my lord, that whole mining. My lord, may I point out one thing? Your lordship kindly, my lord, sees page 20, my lord. Page 20, my lord.
Before that, Mr. Advocate General, we would like to know from you, for what reason the bench, the other bench, on 24/11/2025 was looking at the specific details with regard to the revenue earned.
Revenue, my lord.
Yes, Lord. That also I do not answer, but from one authority I have five.
This is for protecting, stopping all rat hole mining and taking
Yes,
care.
Lord.
A revenue of the.
My lord.
That is what lordship
Probably.
There must
common
be
order.
something behind the reasoning, no?
because
Yeah, under what would it lead to? Suppose I get the information that your net result in bank.
yes, no, whether there is some leakage, that may be the one of the concept. I do not understand also.
Yeah, our view is that with respect to the revenue generation of under a particular head, this TIL is not maintainable. We are not supposed to ask this question. Because we are asking for what?
That lordship, I do not have the privy to look into the minds.
We have to allocate resources which we are not under an obligation to do.
Lord.
And it is beyond our remit. Why should we ask for what is your revenue collection?
And the only thing is that if the revenue is collected through legal means, then there cannot be any.
This is not the question which will give that answer.
Exactly, Lord.
We want to know whether you have stopped rat mining in totality or not.
In fact, that was only on the first day it was started, and on the very first day it lead to the untoward incident.
Leaving this order patched up can create problems. So let me say what this.
Only one thing is that, Lordship, there is a judicial commission which is going on, and last 3 months extension has been granted on 21st.
Who is head that commission?
My Lord Justice retired Anima Hazarika from the retired judge from this honorable court. Another 3 months. That means by 25th of April.
What was the term of reference of that commission?
Including all this, Lordship. I have the reference.
If you have the term of reference, then just give it. Do we close it now?
In fact, a parallel proceeding is going on.
But if the judicial commission is there, why do we
Exactly, Lordship. A very elaborate exercise has been done.
play?
Only in respect of PRL.
Not in respect to other cases. So we will keep it pending, but we'll give a long date. Let's see what happens.
The terms of, sorry.
And in fact, your lordship, the recommendation by the.
Mr. Pota, could you tell me why did you ask for this revenue generation detail?
I don't know.
There's some logic behind it.
My lord.
Asked for it.
Nobody asked.
Not aware why this thing is coming.
Okay. Lordship, may I read the terms of
copy of it?
Yes. It is in the affidavit, page 22 of the affidavit filed by respondent number 1, 2, and 7's affidavit in PIL 1/2025, page 22. 22. Running page 22.
Affidavit by
1, 2, and 7.
The rat hole mining, has it been closed? Has it been stopped?
My lord, may I paint it on one thing?
Clandestinely, if something goes, Lordship, it was done clandestinely. Otherwise, in the nearby area, there is a regulated mining under Assam Mineral Development Corporation.
Can you pass on that copy?
Yes. Everything is covered here, Lord.
This commission of inquiry was appointed when?
It was initiated, the date is 24th January 2025.
Yes, 24 January.
The time limit, have they?
Initially, it has been given for 3 months.
Extended.
Extended.
They have not submitted, she has
Because-
not submitted any report.
No, till now, no.
3 months.
But here, public hearing was going on, lot of other activities had gotten taken. In the area where that actual incident happened, Lordship,
What we propose to do is this.
My lord.
Mr. Mahanta, we are not closing it.
My lord.
Mr. Sakia, what we
Lord.
propose to do is this. Now, we would fix this matter sometimes in June.
Lordship.
And in the meantime, expecting the commission of.
Lord.
In terms of reference, it would take care of any ragful mining in the state of Assam to suggest measures so that such situation incidents are dealt with effectively in future.
Correct.
So that can be
That will
applied
come.
everywhere.
My lord.
And if you tell us any incident, any reported incident of any casualty, even if no casualty, but according to the information that ragful mining
Mine's going on.
carried out.
But in probably in their petition, my lord.
You straight away ask authorities to swing into action.
My lord, another
Let
thing.
it remain open.
My lord, lord.
We are not closing this.
No.
Because it can take dangerous proportions.
Absolutely.
Just go run it with them.
In fact, that area where the incident happened, that was abandoned in 2010 by AMDC after completing the mining there. This time, it's a very remote area. These few these laborers, they went and done it for the first time. And on that very day, it was the incident happened.
None of them have been recovered. No?
All were recovered.
No,
Nine bodies were recovered.
Dead bodies recovered.
Recovered. Government have swung into action. People from the specialized persons from all across the country. All that.
You are also kindly say
Nine dead bodies, if I'm not wrong, correct, were recovered.
In their report, as categorically and these mining for illegal mining.
Yes.
They have taken, they have not come up with an affidavit.
My lord, your lord, my lord, may I point out one thing, my lord, your lordship, kindly, my lord, in their affidavit, they have stated that, my lord, the para 10 of the page 20, kindly see, my lordship, kindly see, page 20, my lord. That regarding the statement made in paragraph 7 of this petition, department stated the standing operation of SOP for stopping the close lateral mining is being prepared. They say that they have SOP, they have prepared to stop this illegal, my lord, lateral mining. But whether that has been already prepared or not, my lord. If prepared, then let them produce before this court, my lord. They say that they are going to prepare.
In fact, if I can just point out that this was the exact stand taken by the authorities 1 year back on 13/2/2025. The same minutes of the meeting have been filed before this honorable court. The affidavit which has been filed before your lordships today, except for the one commission inquiry of Justice Anima Hazarika, all the other annexures are already part of the proceedings of the rest of the PILs way back in 13/2/2025, your lordships. Till date, we are now past 13/2/2026. And till date, we do not know whether the SOP has been formulated or not. Your lordships. That was the stand taken by the authorities even of 1 year back. That was with regard.
SOP has been prepared.
Yes,
I'll
they
have
said
to
that
take up
they've
to
been
date
prepared.
list.
It is in their affidavit by 1, 2, and 7, my lord.
Is being, that means it is in the process.
On 6/1/2025. Now we are giving this legendary part of the litigation. So as to cover up this, so we are not interested in your revenue.
My lord.
Let us have a record of what we are thinking.
In fact, lot of heads roll after this incident.
No,
Government was not sitting idle.
We are stating some facts which may not have been necessary otherwise, but to just give a new direction to this.
Lordship.
Therefore, we are on 6/1/2025. A tragic incident occurred in a coal mine at Umrangso in Dima Hasao district of Assam. Around 4:30 AM, mine laborers had entered into a 340 feet tunnel, which suddenly got flooded by the gushing water from nearby Kopili River. While some could manage to escape, several remained trapped inside. At the time when the writ petition was filed, the bodies of 4 of the laborers had been recovered. While such operation was going on for the rest of the missing laborers, The rescue operation was launched by the National Disaster Response Force, State Disaster Response Force, Coal India, and Indian Army as well. The records reveal that despite commissioning 9 pumps for dewatering the tunnel, it could be flushed out for the reason of direct connectivity with river Proceeding. That also demonstrated that there were no mind maps or blueprints, which otherwise would have made rescue operations easier. The experts had reported that anybody trapped in such tunnel would have been exposed to the acidic water from a lack of oxygen and methane gas inside the tunnel, which would make the fatalities 100%. It was not difficult to ascertain during rescue operations that it was a black hole mine. Involving narrow horizontal tunnel without any safety measures, ventilation, or proper equipment. By its very nature, this kind of mining is hazardous. It's a matter of common knowledge, common the petitioners have contended that such illegal black hole mines have been operated by unscrupulous people who have employed trafficked labor, like men and women, women and children. Like in Meghalaya, realizing the hazardous nature of such mining, in the year 2014, such mining exercise was there at the instance of National Grid Tribunal. However, such hazardous mining activities are, according to the petitioner, continuing across several northeastern states, including USN. Workers driven with poverty and lack of awareness continue to be engaged in such dangerous activities. The operators more often than not maintain no record of laborers, making it almost impossible to determine the exact number of miners inside a given mine. The Scot has been informed that the government of Assam had disbursed ex gratia payment of 10 lakhs to the families of the deceased, and also took steps to close down such illegal mining operations. And formulate a standard operating procedure aimed at stopping a complete, aimed at stopping, aimed at enforcing a complete ban on the black hole mining in the state of Assam. This court had taken suo motu, this court had taken suo motu cognizance of the tragedy and consequently this PIL was initiated as Bhima Sao tragedy case. Mr. Sakya, learned advocate general, learned advocate general, has informed this court that the Commission of Inquiry and Indian Constitution on 24/1/2025 with headed by a one person inquiry, headed by a one person, headed by Justice Anima Hazarika, a former judge of Gauhati Court. In terms of reference of the commission is to ascertain the facts, circumstances and causes leading to the incident of the tragedy, resulting in reported death of 4 persons and several others missing. Semicolon, to ascertain persons / organizations responsible for the illegal activities, if any, of rat hole mining in the area. Semicolon, to determine if there were any lapses on the part of any authority, if so, to fix responsibility thereof. Semicolon, to suggest measures so that such situation / incidents are dealt with effectively in future. This commission of inquiry had to submit its report within 3 months from the date of issuance of the notification of its constitution. But it appears that the commission of inquiry is still continuing with further extensions. The concern of the learned counsel for the petitioners, DJ Chaudhary, Mr. Alpra, what happened from Society Madras? What did it say? The concern. Is that even though the term of reference of the one person commission, right, takes care of all aspects of the matter, but it is limited to Bhima Sao area. Whereas there have been reported instances of rat hole mining in other parts of this state and the neighboring northeastern states. In that context, the learned counsel for the petitioners demand that the SOP as promised by the state should be formulated and made public as expeditiously as possible. The learned advocate general has submitted that it is the process of formulating the SOC is underway. And we would ensure that the whole process is expedited and the SOP is published for SOP is published and the news about the same, news and contents about news about the same and its contents circulated/disseminated in public. It is expected that the Commission of Inquiry shall submit its report within a short time. Adjourning the matter to sometimes in June. Lately, this court cautions this court expects the state to take a proactive measure in stopping the actual in the bad students. And take necessary coercive action against such operators. The petitioners will see at liberty to bring to the notice of the court any known incident of platform money at a particular. In the area. I think this should.
Lordship, in fact, the state government has taken proactive action, which has been put in affidavit also. We have out of 35 districts, only in 3 districts, poll are available, Karbi Anglong, Dima Hasao and Tinsukia. Multiple cases has been initiated against all the illegal offenders. Yeah, that affidavit, Lordship, will kindly come to
Just turn to the
Yes.
page.
page 41.
On the brief.
Yes, additional affidavit. District-wise report we have submitted. There is a
You have separate pull out the unit. We are not able to find out.
Yes.
That is your.
running page 41 in any case, Lordship.
Which may be the relevant ones.
Paragraph 5 onwards. We have considered monitoring committee, surveillance committee, paragraph 4. The DCs, SPs, Director of Geology and Mining and Secretary, Mines and Mineral Development. They are,
The BP cut cake per commission, that is not.
that is, I think it is not here, Lordship. That is.
So this is with regard to PIL 29 and 30 and 39, you know.
That is other.
Wherein the recommendations, in terms of those recommendations, 2 committees have been formulated by the government of Assam.
Committees are there, Lordship.
Yes, 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 Lord. Committees are already there, one headed by the Chief Secretary, one headed by the Director General of Police. Those were the reports which I was posted.
The other PI.
Yes,
Other
other
PI.
Dima Hasao and rest are so far relating to.
Here also,
That committee.
in Tinsukia also we have the report consists of the report regarding Tinsukia. If Lordship is pleased to come to
Yes, yes.
paragraph 5 is Dima Hasao. Tinsukia is paragraph 6, page 46.
The United Advocate General has also. The state for the sign has taken. This. On a very serious note. And another commission of inquiry. Very clever. The former judge of this court. Maybe Justice BP Kadike. Has been prosecuted. Pursuant to the recommendation of the former commission of inquiry, headed by Justice Spanish. A monitoring which is constituted by the state. To monitor the appropriate action by the police against any person involved in raising, storing, and transporting of coal without any valid authority. The committee. The committee. The said committee works under the chairmanship of the Director General of Police Assam. With all the secretaries to the government of Assam. From a home and political department. From all deputy commissioners of coal rich districts. all superintendents of police of all which districts, director from a Directorate of Geology and Mining, and secretary to the government of Assam from a in its mines and mineral department as members. This court has also been informed about the status of different districts in which action has been taken to stop it. The rank for mining. Twice, district wise, beach many.
On 1st June, 36.
Sometimes in June, I think.
Lordship. By that time, the judicial
That.
enquiry commission.
Commission before it's submitted, I think. Anyway, you give us those details.
Yes, Lordship.
And then you also give us in the seat cover, the report of the commission.
Lordship.
Supplementary list, item 40.
Yes.
May please, Your Lordship. Last purpose and honorable court directed to produce the status of Supreme Court this is regarding the Nala case, my lord.
We have fixed all such matters.
Yes, my lord.
Yes. When?
Yeah.
Give us a-
In the month of May, Lordship. But Lordship, this may be fixed separately because this.
You have the number of those cases where.
Yesterday.
Like this. The writ petition is being listed along with.
Yesterday.
Yes, I know. Also.
On 13th May.
Which is scheduled, which has been written. Which group of cases have been.
WPC 6262.
13th May, it was.
Which group of cases have been directed to be listed also?
I have
13.5.
I have a small chair, my lord. In this case, my lord, stay has not been granted, my lord. That may be, my lord. Stay is not there.
Nowhere any.
Must have left.
Daily list for hearing, item 38.
Last time they appeared.
Nobody appeared, nobody has appeared the application on repeated calls even today. So, on the last occasion also, there was no appearance on the application. It appears that the petitioner is lost interest in pursuing this case. This must be known.
Item 39.
Please, Millets.
Yes,
Please, Millets.
yes, Mr. Headgate, can you hear us?
Yes, I can. Can my lords hear me?
Yeah, you are visible and audible both.
For a change, my lords. In fact, on the previous occasion, I was embarrassed because there was a Sri Lankan delegation in the Supreme Court and my signal got jammed and I could.
Today also, your visibility and audibility is not, what is that? Not real time. Not real time.
It is not real time. We are in a virtual world.
Because when your gestures, I mean, the lip movement and sound comes later. But nonetheless, we can do.
Please,
We can.
Manoj.
Yes.
Please. Manoj, this writ petition is filed in the public interest with regard to what is called the pushback policy in respect of certain individuals, some of whom have lost their cases before the foreigners tribunals, some of whom have just been picked up, my lords. We have in this case listed out a whole host of instances, my lords. We have prepared a written submission. I
cannot see Mr. Razak Bhuiyan. I think there is a, please.
Oh, yes, yeah.
Please, my lords. If the written submission in this case could be handed over.
Why don't you,
Just-
though this is quite comfortable for us that you're appearing for Delhi, but why don't you come over on a day fixed where you will argue and we'll have the matter decided. Nonetheless, this is a written submission on behalf of the petitioner. We would ask.
Yes, my lords, I can come after the 25th, my lords, because I just checked the calendar of your lordship's court. And after the 25th in the Supreme Court, we have a couple of days of vacations.
Whichever day you say, but today you argue. If anything is left, you come argue in person.
Please, my lords, I'm also given to understand that the learned advocate general has some problems after around 2:30. But I know he is there, and I can then place my part of it, and he may respond whenever. Please, my lords.
I think the better option would be that we will hear it on any time after 25th of April.
Either the 26th or the 27th, my lords.
Whichever day you say, 26th is Sunday. So 27th.
Sorry, my lords.
April.
26th is Thursday.
Which month?
26th of March.
No, keep it in April. On March, we can hear you on March 26th.
26th of March, my lords.
But let me ask the advocate. Mr. Advocate, do you have any problem today?
26, I'll be meeting.
Today, you have any?
Today, if it is continuous beyond 2:45, I will have some reserve. People.
It shall not continue beyond that.
No, 2:45.
2:45. No, I don't. We can circumscribe his arguments only for some minutes. We'll have to hear.
So either 26th of March or lordship on 28th of April.
26th.
Oh, you are giving dates. No, with a gap of 1 month.
I have no issues otherwise, lordship, in the first week of April.
Either 26th or 27th, my lords, it is quite possible that I can avail of the Advocate General's hospitality.
I'm available. I'm available. I know my dates.
We don't insist for you to come to Gauhati because after all this, all these upgradation of technology is only for this. We only said like that, but just to avoid.
No, coincidentally, there happen to be holidays.
Okay. So we keep it on 27th when the Learned Advocate General also will be available.
27th of this month.
27th of the month.
Lordship.
I'm
Not in 20, like, would it be 26th, lordship?
26th of March. Is it okay?
Please, my lords.
Mr. Gaitan?
Please, my lords.
And we fix a time also so that all of you know when
Lordship.
it will be taken up. At 2.
Please,
At 2.
my lords. Grateful.
Let this matter be listed for filing termination on 27th of March at 2 p.m.
26th.
Sorry, 26th of March.
26th of
2 p.m. Sorry.
Lordship.
26th of March. Please hand over a copy of written submissions.
Yes, yes.
Given us today.
Please, my lords. I rely on a judgment of the Calcutta High Court, my lords, and which may be ruled on in the Supreme Court tomorrow. So that also would have a bearing on things.
All right. All right.
I'm grateful.
All right. But I think it will not.
Please, my lords.
Just yeah. My brother tells me that there is another matter where there is a division bench hearing going on. Individual case of pushback, alleged pushback. So what we do is, can we keep it sometimes in third week of April? Say from 20th to 24th.
Please, my lords, there your lordships will have to may have to hear me virtually. That's about the only thing, my lord. I can't.
We will do with
Please.
it as a request to you that if you find time, come over. It's a 2.5 hour flight.
No, it's not a question of a flight, my lord. Sometimes this, my lords, is a labor of love. But your lordship is also aware of the saying, "Bhukhe bhajan na gaye Gopala." So, so somewhere else.
We would not like you to chant him. इसलिए भूखे भजन करने की जरूरत नहीं है. Let's just make up the issue factual.
This client may go away.
Mr. Bhuya appears to be a bad paymaster, it appears.
No, my lords, Mr. Bhuya has done a lot for the lost, the least, and the last. I can give of my time, I can give of my effort, but
If
sometimes,
it is comfortable for you, but ensure that you have good connectivity on that.
Please, my lords, I will do that.
So we are keeping it, Mr. Advocate General.
23rd or 24th, lordship.
20th Thursday. Thursday is a hearing day. We will
Lordship.
afford all time.
Lordship.
Let this matter be listed for final hearing on 23rd of April at 2 p.m.
Mal.
Right?
Mal.
Deeply obliged.
Deeply obliged.
Grateful, man.
We have a bench is stop the meeting. Stop.